This Honorable Court of Appeals of Tennessee is in session. Please be seated.
This is what happens when I'm not in here.
Musical chairs.
Good afternoon and welcome to the Court of Appeals. I'm sure Judge McBrayer has already explained the procedure to each of you, so I won't go over that again. Miss Angie, anything we need to take up before we call the next case, please?
No, Your Honor.
All right, you may call the next case, please.
State of Tennessee versus Delinquent Taxpayers of Benton County, Tennessee.
May it please the court, my name is Larry Hicks. I represent the appellants in this case. I would like to reserve 3 minutes.
3 minutes?
Yes, Your Honor.
All right, sir. You may proceed.
Okay. Your Honor, the appellant, Tennessee Properties LLC, is a Florida LLC, and their manager and managing member is Martin McGinnis. The only purpose in forming the LLC was to buy 2 lots, waterfront lots on Kentucky Lake, that they purchased in 2006 for $280,000, but they did no business in Tennessee, so they didn't have to file the articles of organization with the Secretary of State if you only own property and do no business. There was a tax sale in Benton County, and the manager member on behalf of Tennessee Properties LLC, Martin McGinnis, redeemed as agent and manager of Tennessee Properties LLC. And on the motion to redeem, which is, I believe, Exhibit 1 in Volume 3, there's a line that says property owner at time of sale, and it was filled out by the clerk and master, Mr. Burris. It says Tennessee Property LLC dash Marty McGinnis, and it lists the address of the property, the 2 lots, and the district, and the maps, and the groups, and parcels, and the deed book page number. And then Mr. McGinnis checked the boxes. It says, I am the taxpayer and or the owner of a legal interest in said property. Then the case of Collier versus Greenbrier Developers, LLC, at 338 Southwest 3rd, 195. This is a 2009 Tennessee Court of Appeal decision. States that, quote, under the LLC Act and the revised LLC Act, managers and members of the LLC are empowered and authorized to execute documents and conveyances of LLC property, citing Tennessee Code Annotated Section 48-238, Sections 101 through 104, 48-249, Sections 401 through 402. Then Tennessee Code Annotated Section 48-202, 101 at Section 38 states, a representative is defined as follows, and then representative means a governor, manager, employee, or other agent of a foreign LLC. In this case, after that proof came in, and other proof, the chancellor held that Mr. McGinnis was acting deceitfully or fraudulently as trying to redeem this property on behalf of Tennessee Properties LLC. There was a request for admissions that she found he didn't answer, although I'll argue that in a moment. He did answer those. He was asked to admit that he redeemed the property individually and not as a representative of Tennessee Properties LLC, which he denied. And he was asked to admit that he was not an interested person pursuant to statute that I've quoted, that I'll argue in minutes for, is the Tennessee Code setting forth the person has a right to redeem any interested person within 1 year following the sale, and then it defines interested person. And I think the articles of organization themselves state that Mr. McGinnis is a manager member, and then on the deed to the property, at the bottom, as your honors know, the person responsible for payment of taxes got Martin McGinnis and had his address set out there. And the purchaser called Ryan Hall, who's the tax assessor there in Benton County, and Mr. Hall testified in the top left corner of the tax cards that it listed Tennessee Properties LLC, care of Martin McGinnis, and he testified and he was called by the purchaser. What that meant was that Tennessee Properties LLC owned the property, but that Martin McGinnis was supposed to be paying the taxes on the property. And then there were other exhibits, maybe 16, I believe, Exhibit 16, Volume 3, that showed where Mr. McGinnis had in fact paid property taxes on that property, and the deed was also filed. It showed he was the responsible party for paying the taxes.
What evidence was before the trial court that indicated that he was the manager or that he could act on behalf of the LLC?
There was the articles of organization, Your Honor, that named him managing member of the LLC.
Did it define what he could do on behalf of the LLC?
It didn't define what he could do, but he testified what he could do, Your Honor. There wasn't any objection as far as what he was responsible to do. And then I think the statute that I just recited, 48-201-101, Section 38, pretty well sets that out. But of course, Collier versus Greenbrier, a Court of Appeals decision, stated that the managers and members of the LLC are empowered and authorized to execute documents and conveyances of LLC property. But to answer Your Honor's question, the document was the articles of organization that I believe they were attached to maybe some of the pleadings by the purchaser, and then they were also introduced at the trial.
And did he, in fact, testify that he was empowered to act on behalf of the LLC?
He did, Your Honor, and that was unrebutted. There wasn't any evidence to the contrary.
Assuming that is correct, then how, in your motion to redeem property, why does it not state that he has that representative capacity?
I would say that it does, Your Honor, please. In the motion to redeem, it said Tennessee Property LLC. It was a misnomer as far as spelling that I've pointed out in my brief, instead of Tennessee Properties LLC, but it does say Tennessee Property LLC / Marty McGinnis. Then in the blocks following that, in the second paragraph, there's a paragraph or a block that Mr. McGinnis checked that I am the taxpayer and or the owner of legal interest in said property. That's in the motion to redeem.
Well, doesn't he really own an interest in the LLC?
Yes, sir. No question about that. But I think I would submit respectfully, Your Honor, that he was redeeming pursuant to the statute as the manager and member of the LLC, which clearly he was according to the articles of organization. And the chancellor struck the motion to redeem, finding he acted fraudulently and that he didn't answer the request for admissions. When he denied, he was asked to admit he was not an interested person, and he denied that. He was asked to admit that you redeemed as an individual capacity and not as in a representative capacity, and he denied that, Your Honor, please. So I respectfully submit that the chancellor was incorrect as far as the evidence, the preponderance of the evidence in this case, the testimony in the case, and the documentary evidence, the articles of organization, and the deed itself indicated who was responsible for the payment of taxes. And then Mr. Ryan Hall, the tax assessor, who testified that according to the tax statement in the records, Benton County, and that was filed, that Martin McGinnis was supposed to be paying the taxes. I respectfully submit to your honors that this case has a great preponderance of the evidence that shows Mr. Martin McGinnis was the person that was responsible to redeem the property as a result of the tax sale. He did so. It was stated on the motion to redeem that he was redeeming the property. And I'll agree there was a misspelling, Tennessee Property LLC rather than Tennessee Properties LLC, but I don't think that ought to be fatal, because he went on to check the box, I am the taxpayer and or the owner of a legal interest in said property. Not just the legal interest in the said property, Your Honor, but also he's the taxpayer, and all the proof showed that he was the taxpayer. He was the one supposed to be redeeming the property. It's a quite valuable piece of property. They gave $280,000 for it.
So, Mr. Hicks, your position is that your client, the property, real property, was co-owned by both the LLC and the managing member?
No.
Okay.
No. Under Tennessee law, if you're a member of the LLC, you have an ownership interest in the LLC. The LLC owns the property. I understand that. But also under the statute and under the law, a member or manager or representative under the statutes and under the case law has the right to redeem that property. I mean, there's not anybody else to redeem it.
Well, let me pose a different question to you.
All right.
This motion to redeem property was filed in the Chancery Court.
Yes.
I'm assuming Mr. McGinnis is not an attorney.
He's not.
And how can Mr. McGinnis act on behalf of the LLC then when, if it were a corporation, an attorney would be required to file a pleading?
I don't think he attempted to represent the LLC in court, Your Honor. He did file a motion to redeem, but I would respectfully submit that's much different than filing a motion in court. It's like the Chancellor stated, and I pointed out in my brief, the other side, the purchaser, was the moving party, and she allowed them to go first as far as proof. I think that under an LLC, if you have a manager or a member, yes, you can redeem, but if there's an objection in the response to the motion to redeem, then you're going to have to hire excuse me, an attorney to go into court, which Mr. McGinnis did on behalf of Tennessee Properties LLC.
Okay. You've used your time. You've got your rebuttal time.
Good afternoon, Your Honors. My name is Robert Whitfield. I'm representing the tax sale purchaser, Ms. Nesbitt, in this case. I suppose the court is aware, but just for purposes of informing the court, that Benton County took no position in this case. They did not participate at the trial court level in the redemption matter. And I believe that John Whitworth, who is the delinquent tax attorney, sent a letter to this court informing the court that Benton County would not be participating in the appeal. So we're the only two attorneys here, and I just wanted to make sure the court was aware of that. I'm of the Henry County Bar, by the way. It's nice to see you all this afternoon. I'd like to take a few minutes to rebut some of the arguments that have been made by the appellant here in the last few minutes. One is, and probably the most fundamental, is the argument that Mr. Marty McGinnis, as a managing member and on behalf of this LLC, filed a redemption motion. That's simply not true. It's on the face of the redemption motion itself. That argument is so disingenuous that the trial court made a finding that it was in bad faith or for a fraudulent purpose. Look at the face of the redemption motion. It says, "Comes now Marty McGinnis and moves the court for an order of redemption." You flip over to the back page. It is signed by Marty McGinnis. His name is printed there. There's no representative capacity indicated either in the first page of the motion or in the signature block, as would be required by the rules of civil procedure. That's cited in the brief. And of course, there are numerous citations in the brief, examples of when Mr. McGinnis has signed paperwork on behalf of the LLC and done so correctly. He knows how to sign in a representative capacity. He had done so many times before. He did so sometimes in the course of this litigation. And this argument that he filed this motion on behalf of the LLC it's just not true, respectfully, to opposing counsel. There's also been a lot of talk about an LLC member's authority to execute conveyances of property, and everyone knows that LLC members can sign deeds. That's not anything new. What's happened here is that a motion was filed in a pending lawsuit in court, and to Your Honor's point, only a licensed attorney can represent an LLC in any sort of a legal proceeding. Opposing counsel has argued today that he thinks the law is that an LLC member could file a motion to redeem property, but number one, he cited no authority to support that point, and number two, that's not what happened in this case. The motion is clear on its face. There's no representative capacity designated. The motion does note that the property owner at the time of the sale was Tennessee Property LLC / Marty McGinnis, but that doesn't say that he's acting in a representative capacity for an LLC, and that's not the correct name of the LLC owner anyway. There might have been ways to fix this. I'm not sure. Maybe there could have been a motion to amend or to correct the owner's name, but for reasons why I can't understand and which led the trial court to find that there was some sort of bad faith or fraud or improper purpose, the opposing party continued with this argument.
What could the possible improper purpose be here?
Oh, I have no idea. To defraud the other LLC members? I mean, it's just bizarre. Why would you argue something that is so clearly contrary to what's on the face of the motion? I mean, it's practically fraud on the court to, maybe it is fraud on the court, to say an LLC filed a motion when an LLC did not file a motion. But the opposing party has said this over and over and over, and that's clearly improper. As I said, it's borderline fraud on the court, and I don't say that lightly. I've never said that about any sort of a legal argument that I've heard an attorney make before in my 12 or so years of practicing law. I don't say it lightly today, but it's a bizarre argument. It's not true. It's just, you just look at the face of the motion. He certainly wishes, in hindsight, and with the benefit of legal counsel, he certainly wishes that the LLC had filed this motion, but what he should have done, or what he wished that he had done, or what he now knows in hindsight he should have done, or rather the LLC should have done, is not what he did. There's been also a suggestion that Mr. McGinnis responded to discovery requests, which is not true. Because he filed the motion, he was served individually with discovery requests, but the LLC, not him individually, responded. He individually never responded to the discovery request, which resulted in these critical facts being deemed admitted. This was called to his attention by the filing of a motion to deem those things admitted, and again, maybe some corrective action could have been taken. Maybe something could have been filed that said, oh, we meant for these to be both from us individually and in a representative capacity for the LLC. But in fact, the opposing party doubled down, and in the response to that motion to deem admitted, the opposing party conceded, yeah, the responses are from the LLC because that's who's at issue here, and what of it? Again, this sort of argument that is just the premise of it is not true, which is that the LLC is the moving party. That's not true. But that argument continues throughout the case, and it hurts Mr. McGinnis in these ways where he fails to appropriately respond to discovery and so on. There was a statement made by opposing counsel here that the deed to the property says that tax notices are to be sent to McGinnis, and I want to point out to the court that's not exactly true. The source of title, and again, hopefully this is not an intentional misrepresentation, the source of title is not a deed. There is a deed recorded, but there's a deed of correction that comes after it, and that is the LLC's source of title to the property that corrected a prior deed. And in the deed of correction, there's no mention whatsoever of Mr. McGinnis's name. But in any event, it's totally irrelevant if he's named to receive tax notices because under Tennessee law, only the property owner is responsible for payment of real property taxes, and anyone can be designated and anyone can request that they be designated to receive the tax bill. The Benton County tax assessor testified to the effect that I can request to get his tax bills and pay his taxes for him if I'd like to. I just need to call his office and let them know, mail the tax bills in care of my address. So, you know, this designation of send mail in care of or send tax notices in care of, number one, it's not exactly true because the deed of correction doesn't mention that or say that or mention McGinnis's name at all, and that's the source of title. And number two, it's irrelevant in any event. There have been some good questions asked. What about the articles of organization? Do they define what McGinnis could or couldn't do? I would point out that those are not recorded. There was absolutely nothing of record in the registrar's office that tied Mr. McGinnis to this property in a way that would make him an interested person within the meaning of the statute. And there was nothing that tied him really to the LLC at all. And in any event, it doesn't matter what the articles of organization say with respect to the authorization to file a legal proceeding. McGinnis is not an attorney. That was stipulated. It's noted in the record. He could not file a motion on behalf of the LLC. Moving back to the other issues and some of the things raised, some of the issues raised by the appellee. As a threshold matter, what has been appealed in this case? The omnibus order filed 18 August, the order regarding post-judgment motions filed later. We don't really know because there was an initial notice of appeal filed and then there was an amended notice of appeal which specified the latter of those two orders. And so we're not even sure if the trial court's initial order on this issue is the subject or the post-judgment motions, the order disposing of those, or both. And we would argue that the amended notice of appeal replaced the original notice of appeal and that the appellant has opted instead to appeal only the order regarding post-judgment motions. And that's significant because the standard is a little bit different. That is the standard of review on appeal. So the other question is, threshold question is, what issues have been raised by the appellant, or have some or all of those issues been waived? There's not even a specific error raised with respect to the trial court deeming certain facts admitted. There's a statement in the brief that, in the statement of issues that, I mean, it's like it's an incomplete sentence. It doesn't even make sense. And the case law is very clear that if you don't articulate an issue in the statement of issues, that you've waived that issue. If he's waived the issues pertaining to what was deemed admitted, he's waived the whole appeal because the appeal turns on these questions of, the substance of it turns on the questions of who filed the motion and was McGinnis an interested person. Both of those things were deemed admitted due to the discovery noncompliance. And if he hasn't effectively raised that as an issue on appeal, you know, the whole appeal goes out. The third threshold question is, does the appellant's argument comply with the rules pertaining to the citation to the record and citation to authority? The brief is woefully deficient. It substantially fails to comply with the rules. There is a tremendous lack of citations, almost to the point of there being virtually no citations to authority in the argument section of the brief. And this court has just fairly recently reiterated that a failure to include appropriate citations in the argument section of the brief specifically waives argument or waives the issues. So that's well established. This court's well aware of it. Just a few months ago, turned down an appeal because it was not properly supported in the argument section. The substantive questions, as I mentioned, if you even get there, are pretty important. Who filed the motion? McGinnis individually did. He was pro se. And I've discussed that in rebuttal, so I'm not going to go on about it, but that's what happens. And the United States Supreme Court has been clear, and this court as recently as, that is the Court of Appeals, Madison County versus Delinquent Taxpayers in 2018 reiterated the United States Supreme Court's holding with regard to Tennessee delinquent tax law. While it may be admitted that a statutory right of redemption is to be favorably regarded, it is nevertheless true that it is a statutory right exclusively, and it can only be claimed in the cases and under the circumstances prescribed. Courts cannot extend the time or make any exceptions not made in the statute. Redemptions cannot be had in equity except as permitted by statute, and then only under such conditions as it may attach. And so there have been some statements made about how much was paid for the property or its valuable property, and that may be an emotional argument. Please let us redeem this because it was valuable and we screwed up. But unfortunately for the appellant, the courts don't have the authority to expand on the redemption statute, and the restrictions that are within that statute are clear. McGinnis individually is not an interested party. He has no ownership interest. He's not a lien holder. He's not a nominee in a deed of trust. So the interested person statute, 67.5.2502 C1B, that's the definition section. And the first part of it's pretty clear. The second part of it is a word salad that means mortgage electronic registration systems. The Tennessee Supreme Court explained that that was the purpose of that particular statutory amendment. And the citations in the brief, but it's Mortgage Electronic Systems, Inc. versus Ditto. That's a delinquent tax case as well. Discussing, I believe it is, discussing 2015 Tennessee Public Acts Chapter 213, and that was the amendment that added this second section that talks about a nominee in a deed of trust or a nominee of indebtedness, something like that. As a final matter, and I've only got about a minute left, there were some evidentiary issues raised on appeal. I'm not sure they're particularly relevant. One is that the operating agreement was excluded. It wasn't produced in discovery. There was no suggestion that it was produced in discovery, and it's not relevant anyway. It's not recorded. It just has no evidentiary value. And then the other evidentiary issue raised on appeal is the qualification of a person who was qualified as an expert abstractor. And I would point out that McGinnis, as the moving party, had the burden to prove that he was the interested person. It was not the respondent's responsibility to disprove that, but nevertheless, and how do you prove a negative anyway? How do you prove that something is not recorded in the registrar's office? Well, you have an abstractor who's done this hundreds and hundreds and hundreds of times, review the records, and find out it's not there. So, there was an affirmative disproving of this allegation that McGinnis was an interested person. And finally, we've asked for attorney's fees on appeal on the basis that this is a frivolous appeal. I think the reason for that is, number one, the reiteration of this argument that's just patently not true, that an LLC was a moving party when a natural person clearly was the moving party. And also the failure to appropriately brief this issue, both in the statement of issues and in the argument section of the brief. Thank you, Your Honors.
Thank you.
Did I have any time left?
You have 3 minutes.
Briefly, again, I still respectfully submit that if you look at the motion to redeem, it states that Tennessee Property LLC / Marty McGinnis. And then the box was checked that he was the taxpayer.
So your position is that Mr. McGinnis had the, authority to file that motion?
Yes, Your Honor.
And I say that because it is an LLC.
Yes.
And I didn't quite understand the distinction you made as to why that was not a legal document or a motion in an actual court proceeding.
Okay. I think that the trial court actually recognized that because she told the purchaser to go first, that it was his motion. I guess it would be up to Your Honors to determine whether that was a judicial proceeding to file a motion to redeem or not.
Isn't it litigation? Isn't it an ongoing case?
Only, Your Honor, if the purchaser contests it, then it becomes a litigated matter.
Well, when I was chancellor, and I'm sure Judge Golden can speak to this as well,
Yes, sir.
we had many tax cases, and in order to get a tax case started, they had to file litigation in Chancery Court.
I think if it was something challenging the constitutionality or the legitimacy of the tax sale, that's true. But the motion to redeem, I mean, like Collier versus Greenbrier, the Court of Appeals in 2009 stated.
Let me help y'all. Y'all have all quoted Collier versus Greenbrier. I wrote Collier versus Greenbrier.
Well, yeah, then maybe I'm off base, Your Honor, but I mean, that's what I understood and read the case. That's what it said, that they were empowered to file documents and all on behalf of the LLC.
Go ahead, I'm sorry.
And then the statutes give the manager member, the same authority if you look at the statute. So we're not trying to be fraudulent, not trying to be deceitful. There was no one else that could file the motion to redeem, respectfully submitted. If we're wrong, we're wrong. But I mean, that's.
Could an attorney file the motion to redeem on behalf of the LLC?
If he was representing Martin McGinnis, I suppose so, Your Honor, please. But I think he would have to be
But can an attorney represent an LLC?
If he was representing the LLC, I suppose you could, but who's going to, I mean, a manager member, someone's got to hire him. That's what Mr. McGinnis did to me to represent him in this lawsuit.
Isn't it the same way you would represent a corporation, though?
I don't think so.
Okay. Thank you, sir.
Thank you.
Gentlemen, we appreciate your argument. We will do our best to get you an opinion as quickly as possible, and we'll take this matter under advisement until that time. Thank you. Miss Angie, if you would call the next case, please.